All right, in this video, I'll be explaining the discovery process. You've probably heard the word discovery in the context of criminal cases and may have been wondering what it means. Well, we're going to explain it in this video. And this is actually the second video in our series in which we're walking you through the timeline of a criminal case. We started with the arraignment process, and that was the first video, and we'll go ahead and link that up above if you didn't get a chance to see that. But now we're on to the discovery phase. So what is discovery? Discovery is basically the exchange of information between the parties in a case. So you have the defense, you have the prosecution, they're exchanging information about the case. The vast majority of the information is going to be shared by the prosecution to the defense. And this is because, the government is charging you with the crime, right? The government has the burden of proof. The government has the burden of proof of guilt beyond a reasonable doubt, right? So since they're the ones bringing the case, they're going to be the ones providing the bulk of the information. Now, the defense can also provide discovery, and in some cases they should, right? And that's going to be the results of the defense investigation. And we'll have a video later on in the series on defense investigation, but as part of the, defense investigatory process, that is how there may be discovery provided by the defense to the prosecution. So the next question would be, okay, what type of information does the prosecutor provide? And the primary source of information is going to be by way of police reports, right? So when the police are conducting their investigation, they have their notepads and they're taking down notes of their observations, the things that they see. They're looking at the scenes, they're looking at the witnesses, and they're taking notes, and those notes end up being a police report. And so the police report is basically the memorialization or the documentation of their notes and what their observations were. Police reports become very important later on down the road because, an incident can happen, let's say on New Year's Eve going into New Year's Day. So January 1, the officers are taking down their notes and creating a report. By the time the case gets to court, whether that's to go to a preliminary hearing or go to trial, it could be 6 months down the road, a year down the road, even a couple of years, depending on the case. And so that officer is going to have interviewed hundreds, if not thousands of people by the time they get to trial on that case. And so they need to be able to have an accurate means to refresh their recollection as to what happened on that particular, incident. Because again, especially if it's a domestic violence incident or a DUI, they just see those so many times. Unless something happened way out of the ordinary, then there's not going to be anything that, really causes them to recall specifically that particular case. So by looking at the reports, they're able to remember what ended up happening on that particular date and time. It is indicative of what the evidence would be at trial if the case were to go to trial. So a big part of the police reports are witness statements, right? So the police, as part of their investigation, they're going to interview the witnesses on the scene, if there are any. Sometimes it might just be an alleged victim. We handle a lot of domestic violence cases, and so if there's a 911 call, whether that's from the alleged victim, sometimes, the person who called 911 is the one who ends up getting arrested. Sometimes people have just bad luck like that, or neighbors might have called 911, and then the police are going to respond and they're going to interview the parties. And if those parties give statements, then those are going to be part of the police reports. You're also going to get photographs, right? So the officers, and nowadays they just use their cell phones. They'll go around taking pictures of things that they deem relevant, and that will be part of the discovery. You also get videos, right? So nowadays, all officers, they're going to have those cameras on their chests, and those are called body-worn cameras. So you're going to get the body-worn camera footage. And the important thing about, there's a bunch of important things about body-worn camera footage. If nothing else, the body-worn cameras are in part designed to keep the officers honest, right? If you're constantly being watched, if your actions are being watched, then, you'd like to think that cops are just going to do the right thing all the time just because that's what they're supposed to do. But, those cameras keep them honest on some level. But the other part of it is that the way they use it is, as they're going and checking out a scene, those body worn cameras are on and they're capturing what the officer is observing. Also, while they're interviewing witnesses, then you're actually getting to see the actual footage of the witness. And this can be really important because it's one thing to see the police report, which captures a witness statement, but that can also have the officer's interpretation of what the witness said. So it's not a verbatim transcript, right? Those are just the reports of what the witness said. And sometimes, in fact, oftentimes, they're very slanted towards, the evidence that the officer wanted to collect in order to, establish probable cause for the arrest and obviously to build the case for the DA down the road in order to file charges against you. So that's where having an actual video recording of the witness statement is helpful, because then we get to see, we get to analyze their body language. We get to see how they answer questions. Are they evasive? Are they forthcoming? Does it seem like they're telling the truth? Does it seem like they're very interested in providing the responses, or are they a little standoffish? All those things factor in to our investigation. So those videos are really important. In DUI cases, you'll oftentimes get the patrol unit dash cam footage. And this can be important because if the patrol unit's dash camera is on while they're observing the driving, then, when it comes to DUIs, in terms of them forming probable cause for the stop, there are a whole bunch of cues that can be cited as their basis for pulling over a vehicle, which then may lead to a DUI investigation. So if they have on their camera that, that the tail lights were off at night, or the car was straddling lanes, or was weaving between lanes, or was going at an extremely high rate of speed, or was going at a really slow rate of speed, there's all kinds of things that can be captured, and that will be part of what you're able to see on the dash cam footage. Those are oftentimes also used in evading cases. So let's just say there's a situation where an officer activates their emergency lights and they go to pull a person over, and then the car ends up taking off. They may then turn on that dash cam in order to capture the chase that was going on. In violent cases where there may have been an assault with a deadly weapon, if the person went to the hospital or otherwise sought medical attention, then medical records can be a part of the discovery as well. And that can be a way to assess the seriousness or lack thereof of a person's injuries. In financial cases, if, let's say there's embezzlement or some sort of theft, then, evidence of those transactions. So you might get logs. And sometimes in these financial cases, you have hundreds of pages of evidence to go through that the prosecutor believes indicates that person stole from a company, whether that's their employer or another company or an insurance company, a fraud case or something like that. So oftentimes in what we call paper cases, then you're going to see a lot of that information. If it's a drug case, you might have pictures or videos of the contraband, right? So if they did what was a cocaine bust or, a fentanyl bust, then they're going to have pictures of that information. You're also going to get lab reports, right? So oftentimes the officers will eye the controlled substance, and they're trained to recognize controlled substances. They may have a mini lab kit to do an initial test, and then when it gets back to the station and goes to the lab, then they'll have it actually tested by a chemist, and then they'll indicate what was the actual substance, what was the weight, and they'll have photographs of that. Social media is a really big player these days when it comes to law enforcement investigations. Please understand that they are looking through Facebook pages, Instagram pages, Twitter, all of this stuff to find anything that they can to basically bolster up their case. And I've seen a lot of cases where a person's Facebook posts or videos were what really sealed the deal in terms of building a case against a client. And so that can be a big thing. So you really want to watch what you're posting on social media. And, when it comes to the timing of providing discovery, this is supposed to happen in a reasonable fashion. There's a deadline, generally 30 days before trial. All discovery must be provided. There can be exceptions to that rule. If the prosecutor or the defense comes across evidence that they didn't otherwise have access to, and it's within that time, then that can be proposed to the court that evidence still be considered admissible. But part of the reason why I say that is, when you watch TV and the movies, sometimes there will be like a surprise attack of evidence, right? Where the district attorney plops down, a mountain of evidence the day before trial, and that, blows up the whole defense. And while that makes for really good TV drama and movie drama, that it just doesn't happen, right? Prosecutors have an ethical duty to not just sit on evidence. They have a duty to get that information over to the prosecutor or over to the defense. One other piece of information that you may not have been aware of is something called exculpatory information. And exculpatory information basically is material information that tends to prove that a person is not guilty of the offenses charged. So prosecutors, it's not just about providing the defense with the evidence that points to the client's guilt. Obviously, they're going to provide that information, but they also, if they have it in their possession, if they have any evidence that points to the client's innocence or not being guilty of the offenses charged, then they have a duty to turn that over. An example of that would be, let's say, there might have been a witness who saw a shooting, right? We're talking about a shooting, and your client was wearing, all black, right? He was wearing all black, and one of the witnesses says that the shooter actually was wearing a red sweater and a red baseball cap. If your client was wearing all black, then, that's going to be inconsistent, right? If you have other witness statements indicating that, I saw the guy who was wearing all black fire the shots, and then this other witness says, oh no, the guy who fired the shots was not the guy in all black, it was the guy with the red cap and the red t-shirt, then that's going to be exculpatory information, because it tends to call into question whether or not, your client was actually guilty. So prosecutors have to turn that information over. So now that we have a better understanding of what discovery is, then the next question is, well, what do we actually do with the discovery? And so, we as defense attorneys, we understand that the prosecutor, again, has the burden of proving every single charge beyond a reasonable doubt. And so what we're looking at is when we have the complaint, and the complaint is going to list all the charges and allegations, what we can do is go to what are called the jury instructions, right? So the jury is given a series of instructions in order to instruct them on the law so that they can apply the facts of the case. They'll look at the law and see if the prosecutor has been able to meet their burden of proof, right? So each crime has a number of elements that must be fulfilled, each and every element of the crime, in order for the defendant to be found guilty. And so we're looking at those instructions as we look through the police reports and evidence, so we can see where might be the issues that the prosecutor might have problems proving their case. Where might there be some sort of red flags that go up in terms of police doing, cutting corners or violating our client's rights? Were there some sort of Miranda issues? Did they get a statement from our client without reading them their rights? Was there probable cause for the stop? These different issues that we're looking at. And so we, kind of take notes on our initial thoughts, and then we'll go over it with the client. And this is where, I want to say this is where the magic happens, but this is probably one of the most valuable parts of the defense of a case. That is actually sitting down with your client and going through the reports, because at the end of the day, the prosecutor is trying to say that you're guilty of something, right? And so, the prosecutor wasn't there, right? The prosecutor wasn't there. He wasn't sitting there observing what was going on. A lot of times the police weren't there either, right? The police are getting there after the fact, unless it's a situation where, they're running surveillance, and, most times, unless you're, involved in drugs or some sort of crazy criminal activity, you're not going to have been surveilled prior to or during the time that the incident is happening. So the police are coming after the fact, and the DA is getting the information from the police. So you as the client are going to be, you're going to know the most about the situation. And so we're able to sit down with you and go through those reports, and you're then able to say, okay, this is a lie. This is an exaggeration. This didn't happen this way. This actually happened this way. I can prove this person's lying. This is the truth. And by going through that, we're then able to begin forming our defense strategy, which will also lead to, us having our investigator go out and get statements as well, right? Because we'll have been provided the statements from the prosecution's witness or witnesses and the police and the like, but we want to go out and get our witness statements as well. Sometimes we'll have our defense investigator actually interview the same witnesses that the police interviewed. And it can be completely different, right? Because again, if the police are trying to build probable cause to arrest you or be able to build a case for the DA to prosecute you, sometimes they're going to leave certain things out that would have been helpful to you. And by being able to have our defense investigator go out and get those statements, that can be really helpful. And so we're going to, like I said, we're going to get to defense investigation a little later on, but that kind of gives you an overview of discovery, what it is. So we went over what it is. We went over how it's used and how that's just such an integral part of the defense. The defense attorney going through it with his team, paralegals, other attorneys, investigators, and then going through it with the client so that the client can point out all the inconsistencies, the lies, or, being able to admit, yeah, okay, they got me. And if that's the case, because, that is sometimes the case, right? Sometimes they actually have you dead to rights. They may have had you on camera, or they have, 11 witnesses all saying the same thing. In that situation, we might need to shift gears and modify our defense strategy in order to perhaps provide context. Why did this happen? What was, there may be a legal justification, right? So yeah, you pulled out the little miniature Padres bat that you had and beat the guy with it, but that's because, he had swung at you first, or he swung a beer bottle at you, or he threatened to pull out a knife and cut you. And so you wanted to act before he acted first, right? So there can be, legal justifications, there can be context, there can be all kinds of different ways that we're able to defend a case, even though our client did what they're alleged to have done. So that's where that interactive process is really, really important as part of a defense investigation. So I hope you got something useful out of this. Leave me some comments below if you have any questions, you want elaboration on more of these issues. Readiness Conference will be the next step in this series, which is the hearing in which we're determining, is the case in a misdemeanor ready to go to trial, or is it ready to go to a preliminary hearing in a felony case? So again, like, subscribe, turn on notifications. Thanks so much for watching. Until next time, peace.